Good morning, ladies and gentlemen. My name is Klip. I'm a professor of criminal law and criminal procedure of Maastricht University. This is a presentation for the European Criminal Justice Observatory on 3 legal instruments of the European Union in criminal sanctions: mutual recognitions of sanctions, decisions on probation, and decisions on provisional detention. The 3 new framework decisions I'd like to deal with today are Framework Decision 2008-909 on the mutual recognitions of custodial sentences on measures involving the privations of liberty. The second is Framework Decision 2008-947 on mutual recognition of judgments and probation decisions with a view to supervision of probation measures and alternative sanctions. And the third is Framework Decision 2009-829 with regard to decisions on supervision measures as an alternative to provisional detention. Ladies and gentlemen, these 3 framework decisions are a follow-up of the introduction of mutual recognition as a cornerstone principle. At the summit of the European Union in Tampere 1988, the principle of mutual recognition was introduced as the cornerstone principle, which means that it is applicable with regard to all forms of cooperation in criminal matters in the European Union. Mutual recognition has been introduced as the cornerstone principle for cooperation in criminal matters, which means that all forms of cooperation are subject to the application of the principle of mutual recognition. This means that, for instance, in the area of the European arrest warrant, the surrender proceedings, the principle is applicable, but also with regard to the application of the principle in the area of transfer of judgments in criminal matters. It's a general application of the principle of mutual recognition, and it also means that the principle will be interpreted in a similar manner in all areas of cooperation. The European Union has, over the years, especially since 2004, expanded with regard to all modalities of cooperation. So there is now European Union legislation with regard to police cooperation, the very early beginnings of criminal proceedings, with regard to collection of evidence, with regard to the transfer of proceedings in criminal matters, and with regard to confiscation measures and the measures that I will deal with today with regard to the transfer of proceedings, with the transfer of criminal judgments. What is essential with regard to mutual recognition is that it sets its own priorities. So the very fact that a member state sends a request for a transfer of judgment is a priority setting by the member state that takes the initiative. That is a breach with what we had in the past. In essence, we can say that mutual recognition creates a division of tasks with regard to cooperation in criminal matters. The issuing member states deals with the question whether the measure as such is necessary, whether it is necessary to send out an arrest warrant, whether it is necessary to ask another member state to execute a criminal judgment. It also deals with the question whether there is a list offense. As you may know, the current instruments, the 3 instruments that I will later on expand on, apply the same list of 32 offenses that the European arrest warrant framework decision applied, which means that for those offenses, double criminality is no longer necessary. The issuing member state, it's their task to decide whether the offense at stake is one of those list offenses. The task of the executing member states are different. The executing member state has the task to decide whether one of the grounds for refusal are applicable. That is an exclusive task of the executing member state. It also must assess whether there is double criminality for those offences that are not subject to the list offences. And in one of the last, but certainly not the least subject, the executing member state must assess whether the measure is in the interest of the convicted or accused person. And that member state must balance whether the measure requested is in compliance with the rights and obligation of the individual at stake. Ladies and gentlemen, the Framework Decision 2008-909 on the mutual recognition of custodial sentences and other measures of deprivation of liberty replaces the Council of Europe Convention of 1983. That as such is extraordinary because this Council of Europe Convention has been one of the most successful, not to say the most successful convention of the Council of Europe. It did achieve 64 ratifications. No other convention on mutual cooperation, mutual assistance in criminal matters has achieved such a high number of ratifications. And one of the expectations for that is that it does not carry obligations. It does create quite a number of possibilities to cooperate, but it does not oblige member states, it does not oblige party states to cooperate. Everything is possible, nothing is obligatory. We change from that situation where no obligations exist into a situation in which there is an obligation, and that is present under the Framework Decision 2008-909. The goal of that framework decision is to facilitate the social rehabilitation of the sentenced person. You'll find that provided in Article 3 of the framework decision, and that is the goal on the basis of which the necessity of the measure must be assessed. Unlike the Council of Europe Convention of 1983, the consent of the convicted person is no longer necessary, which means that the transfer of a judgment may take place contrary to the will of the sentenced person. It may be anticipated that this will create quite a number of cases because unlike the previous situation where consent was given by definition, in this situation no consent may be required. As stated already, the framework decision creates an obligation, which means that a member state must recognize unless it can apply grounds for refusal. Another change with the previous situation is that no conversion of the sentence may take place anymore. The system under the framework decision is a system of contingent enforcement, which means that the sentence as imposed by the issuing member state must be executed. As a corollary of the creation of an obligation, also grounds for refusal have been introduced. So for the first time, with regard to this form of cooperation, grounds for refusal are applicable. It is the legislation of the member states of execution that governs the enforcement, including all aspects that relate to it, the early release, issues of amnesty, issues whether pardon may be given. These are all matters that are governed by the legislation of the member state of execution. Member states should have implemented by the 5th of December 2011 at the latest, but you may have noticed that many member states did not meet that deadline. It's one of the questions still outstanding, what the consequences are of late implementation with regard to the rights of individuals. Ladies and gentlemen, the application of this framework decision differs from member state to member state. With regard to all member states, except Poland and the Netherlands, the framework decision applies to requests since the 5th of December 2011, on condition that the both cooperating member states have implemented into their national legislation the framework decision. That is the rule for all member states except Poland and the Netherlands. Poland and the Netherlands made a specific declaration with regards to this framework decision as provided in Article 28 of the framework decision, which leads to a situation that for those states, judgments rendered after the 5th of December 2011 are the only judgments eligible to be transferred under the framework decision. So it's an entirely different situation for most member states. All judgments, even dating from before the 5th of December 2011, may be transferred as long as the request comes in later, but for the Netherlands and Poland, only more recent decisions qualify. Also, for those countries, it is absolutely necessary that both member states that wish to cooperate have implemented the framework decision into their national legislation. There's a further exception with regard to Poland, and that relates to the issue of consent. Judgments rendered before the 5th of December 2016 require consent of the relevant convicted person. That relates both to Polish citizens being brought back to Poland, as with regard to non-Polish citizens convicted in Poland that may be eligible to be transferred to other member states. Still, their consent is required as it was required under the Convention on the Transfer of Sentenced Persons of the Council of Europe. I'd like to deal more specifically with a couple of aspects of enforcement of foreign judgment. As mentioned already, the system now is exclusively a system of contingent enforcement. This means that a nominal sentence imposed by the sentencing state must be executed by the enforcement state. This means that, for instance, 10 years imposed by a court in England must be executed when the sentence is transferred to a court, to a member state elsewhere in the European Union. There are a few possibilities of adapting the sentence to the system of the enforcing state. And these possibilities, these exceptions to the general rule that the nominal sentence must be enforced, relate to incompatibility with the enforcement legal system. You may find those exceptions provided in Article 8 of the Framework Decision. There is, for instance, an exception with regard to incompatibility with regard to the maximum penalty. If the 10 years imposed in England are higher than, for instance, the legislation provided in the enforcing member states, let's say France. France only provides for a maximum penalty of 8 years with regard to the specific crime, then the French rules will be leading, and the maximum penalty imposed in France will be enforced. Other possibilities to adapt the sentence relate to the incompatibility of the modality of the sentence. If the member states that has sentenced the person provides for a modality of a sentence that is unknown to the enforcing member state may adapt the sentence into a sentence that is similar to the sentence that was imposed in the sentencing member state. When adapting sentences, member states must comply with the threshold that is provided in paragraph 3 of Article 8 of the Framework Decision, and that threshold is that the adapted sentence shall not aggravate the sentence passed in the issuing member state in terms of its nature or duration. So, in other words, the penal position of the convicted person may not be aggravated. Ladies and gentlemen, there are a couple of consequences that result from the existence and the application now of these framework decisions on the transfer of judgment. And one of the consequences is that it must be anticipated more often than in the past that EU nationals standing trial in other member states will at a certain moment be transferred back to their country of origin. And the rules applicable in the transfer proceeding and the rules applicable with regard to continued enforcement lead to a couple of issues that must be anticipated in the trial already before a decision to transfer has been taken. One of the issues is that the chance to be transferred is relatively high. It is the wish of the European Commission that nationals of a specific member state will have the sentence executed in their state of origin. This offers, in general, better chances for social rehabilitation, and therefore there is a stimulus, there is certainly an incentive that EU nationals will be transferred back to their state of origin. However, one of the consequences is that their legal position must be analysed much more closely than in the past, and especially the legal position as a consequence of the specific combination of the two member states must be analysed. Within the European Union, there is a wide variety of detention facilities. Some detention facilities are certainly much better than other detention facilities. In addition to that, there is a wide variety of rules on early release. In some member states, it is possible to obtain an early release, a conditional early release, already after 1/3 of the sentence executed. In other member states, that is not possible at all, and is only possible to be released after 2/3 of the sentence executed. So that variety creates different treatment. So the combination of different standards with regard to detention facilities and different rules with regard to early release may lead to situations in which the very fact that a convicted person is being transferred from one member state to another has the consequence that a person may spend more time in prison than he would have spent when he would not have been transferred at all. It may also lead to a situation in which the convicted person will receive a much shorter penalty to be executed than when he would have stayed in the member state that sentenced him. I'd like to make that clear with an example. For instance, the Netherlands have a relatively mild climate when it comes to sentencing. Nominal sentences are comparable to other EU member states, relatively low. However, this is combined with a very stringent regime on early release. No prisoner in the Netherlands will be released before 2/3 of their prison sentence has lapsed. That is comparable to other member states in the European Union, a very severe system of early release. Other member states may have the opposite, may have a very severe sentencing regime, but a very lenient system of early release, and may, for instance, may create a possibility that prisoners will be released after 1/3 of their prison sentence complied on certain conditions. Member states also differ with regard to the fact whether the early release is predictable in the sense that there is a right to early release, or whether it is conditional. And member states differ with regard to the moments at which these conditions can be fulfilled, or with regard to the moment that a prisoner may apply to be tested whether pardon or early release is possible. It is relevant to anticipate the consequences, and it is relevant to deal with these issues at the moment of sentencing. I'd now like to deal with the second framework decision, the decision, framework decision 2008-947 on probation measures and alternative sanctions. The system of this framework decision is similar to the previous one, with the exception that now only in principle the supervision is transferred from one member state to another. This decision relates to judgments that incorporate a certain conditional sentence or incorporate a certain alternative sentence. With regard to the conditional sentences, the member state of enforcement will supervise whether the conditions to be complied with by the convicted person are complied by that person. It relates to a wide variety of measures, whereas with the previous framework decision, measures relating to imprisonment do not vary that much. We can expect within the European Union, when it comes to conditional sentences, that there is a panoply of measures, which also means that in certain situations, member states must adapt the decision imposed into their own national system, because of the fact that the measure imposed by the sentencing state is unknown to the enforcement state. Not all measures may be compatible within within the member states of enforcement. When it comes to the supervision of the conditions imposed by the sentencing state, it is the executing member state that decides whether the conditions are respected. It is the executing member state that will also take the decisions necessary as a follow-up when the conditions are breached. So if, for instance, one of the general conditions will always be that a convicted person may not commit a new offense. If that offense has been committed, the conditions are breached, and the member state of execution will subsequently enforce the sentence that is being imposed when that condition is breached. It is that the member state's decision to follow up to that. Again, like with the framework decision on the transfer of unconditional sentences, some anticipation is required during the trials with regard to EU nationals in other EU member states. With regard to conditional sentences, it is even more important to anticipate during the trial proceedings on the question whether the transfer of judgment may take place. Why is that so? The Commission has identified that EU nationals, more often than nationals of a trial state, risk to be convicted to unconditional sentences. And the Commission has identified that the social rehabilitation of the offender is facilitated when conditional sentences are imposed. So, in trial proceedings, where in similar situations nationals of that member state would be eligible to a conditional sentence, it is important that the possibility to transfer conditional sentence with regard to EU nationals is considered. This means that in sentencing hearings, in the procedure in which the decision is made whether a sentence will be imposed, the possibility of transferring the supervision must be discussed. And especially in the early years of the application of this framework decision, it is very relevant to illustrate the possibilities and the safeguards of this new procedure. Ladies and gentlemen, it is also relevant to deal with a couple of uncertainties. Uncertainties with regard especially to the penal position of the convicted person. There are, in essence, in my opinion, three uncertainties that must be addressed. The first is that it is unsure whether the sentencing member states will offer the decision for a transfer to another member state. It is the discretion of the sentencing member state, and there's no right to be transferred to another member state. The second uncertainty is that if that member state, if the sentencing member states decide to transfer, it is uncertain when it will do so. There's no indication at all. There's no instrument, no possibility to influence the moment when that decision is taken. The third uncertainty is that many member states apply conditional systems of early release, and that makes the consequences, the final consequences of a transfer very unpredictable for the convicted person. So three moments of uncertainty which require to be addressed in the practice in the coming years and may have to lead to a certain amendment of the practice in the member states. Finally, the third instrument I'd like to present to you is Framework Decision 2009-829 relating to the mutual recognition of the supervision as an alternative to provisional detention. The implementation period for this Framework Decision lapsed on the 1st of December 2012. What is the goal of this Framework Decision? Well, the goal is to reduce provisional detention of non-citizens in other EU member states. And at the same time, it has the goal to guarantee, to safeguard the presence of that accused for trial. Similarly to the situation in which EU nationals find themselves when it comes to the imposition of unconditional sentences, also with regard to provisional detention, it has been identified that EU nationals, non-citizens, have a far more higher risk to be put into provisional detention than nationals of that member state. And the idea that explains that is that with regard to non-citizens, there's a fair risk that that person will abscond and will not be present for the criminal proceedings. This measure is a measure to combat that fear and to combat the situation that non-citizens will spend much more time in provisional detention than citizens of that member state. If you look at the practice of member states, you will see once again, quite a variety. Some member states practice provisional detention at a very high scale. We may mention Italy and the Netherlands, for instance, in which approximately 35% of the detention population consists of prisoners in provisional detention, whereas other member states have a prisoner rate of provisional detention of less than 10%. So the practice of member states differs quite a lot. This is a measure that should be taken whilst the criminal proceedings are still pending. It is a measure that should be taken at the early stage of the criminal proceedings, and it is a measure that should safeguard, should guarantee the availability of the accused person at the trial in the member states. With regard to the supervision measures, we may see an extreme variety of measures that can be imposed by the member states. You will find in Article 8 of the Framework Decision a whole list of supervision measures that are provided, measures to report, measures to report to the police stations, measures to remain within a certain city, within a certain location, and all kinds of other measures that can be supervised by the member state that accepts the supervision of this measure. It is the executing member states that monitors the accused conduct. It's the executing member states that will report to the issuing member state whether that conditions have been breached. And if that is the case, the issuing member states may send a European arrest warrant, and the individual will be brought immediately back to the member states that is conducting a criminal proceeding against that person. So this, in essence, explains the two goals, is exemplary for the two goals of this legal instrument. It creates the possibility that the accused person will remain in freedom and may await his criminal trial outside prison. And on the other hand, the second goal, his presence, his availability for the criminal trial is guaranteed by the measure of the European arrest warrant. Ladies and gentlemen, I'd like to conclude with highlighting a couple of challenges for the future. Challenges because we now enter a situation that ends the exclusive applicability of the European arrest warrant in surrender proceedings on the basis of the mutual recognition procedure. In the first years of the European arrest warrant procedure, we had that procedure only on the basis of mutual recognition, but now we have other procedures also applicable. And that means that we have alternatives to European arrest warrant procedures. The alternatives will have their influence when it comes to making decisions on whether to choose either, for instance, for a European arrest warrant procedure or for the transfer of judgment. This relates also to the proportionality of the measure chosen. In certain situations, it may be less infringing upon the rights of the individual to transfer the judgment than to transfer than to surrender the person from one member state to another. Ladies and gentlemen, this concludes my presentation on the main aspects of three legal instruments of the European Union with regard to transfer of judgments, with regard to the transfer of probation measures, and with regard to supervision measures with regard to an alternative for provisional detention. Thank you very much for your attention.